This is WTIC's Law Talk, a project of the Hartford County Bar Association. If you have a legal question, call now at 522-WTIC, 800-966-WTIC. And now it's time for Law Talk on WTIC News Talk 1080 and WTIC.com.
All right. Welcome, everybody, to Law Talk right here on WTIC, News Talk 1080, WTIC.com, streaming audio on the net. I'm Attorney John Metoulis from the Hartford County Bar Association, and it is my pleasure to host these Saturday afternoon interactive legal toolboxes where we dispense information, answer questions, try to give you some help navigating that thicket of rules and regulations and statutes that seem to bedevil all of us one time or another. We're going to have some very, very good help today. Attorney Brendan Daly is with me. Brendan is a principal in the law firm of Cepeda, Daly, Pope and works primarily out of its Berlin office. He practices in the areas of elder law, estate and disability planning, and estate administration. He has earned the designation of Certified Elder Law Attorney and has been selected as a top attorney by Super Lawyers, which is a designation awarded to the top 5% of attorneys, and he's received that award for 6 consecutive years. Brendan is a graduate of Quinnipiac University School of Law, is a frequent speaker on topics of elder law and estate planning for all kinds of different organizations, community-based, professional organizations, you name it. He's also a member of the executive and steering committee of the Elder Law section of the Connecticut Bar Association, the Estates and Probates section of the Connecticut Bar, the National Academy of Elder Law Attorneys, where he sits on several committees of the Connecticut chapter and is a past president and board member. He's also published numerous articles regarding estate planning, Medicaid, long-term care. Brendan, welcome back to Law Talk.
Thanks for having me, John.
Glad to have you with us. Just want to stress to listeners that we're here until 4 o'clock and 4 o'clock only. If you've got a question in this topic, this is an excellent opportunity to get some advice that is going to be very thorough and very comprehensive. Brendan is a specialist and he's extremely highly regarded by his colleagues in the profession. You're going to get good quality answers, and this is something we do as a public service. Brendan, just to get us started here, one of the topics that I know you mentioned, there seems to be a lot of interest among your clients, and I suspect among our listeners, it is what is called asset protection planning for long-term care. So maybe you can get us started here by telling us basically what that is and why that's important for folks.
Sure. It all has to do with the cost of long-term care, and it's the most expensive in Connecticut.
This would be convalescent home care?
Yes, correct. Skilled nursing care. And so the average is about $13,000 to $14,000 a month.
Wow.
And for that reason, people will deplete their life savings very, very quickly if they have a lengthy nursing home stay.
I can see that would burn through a comfortable size estate very, very quickly.
Sure.
So what kind of planning do people do if this is something that they're concerned about on their horizon?
Okay. What that involves is transferring assets, making gifts, transferring properties, real estate, whatever investments that they have to normally a younger generation, to their children.
So I'm going to guess that there are probably some rules about this stuff, and that you don't just willy-nilly go and decide to give everything to the kids in order to either create or enhance your eligibility for this is all for Medicaid, isn't it?
This is all for Medicaid,
okay.
Yes. That would be a huge mistake to do that.
Well, tell us why, because
okay.
I know we have people that come in and say, well, I'm getting on in years. If I go into a convalescent home, I don't want the kids to have my whole inheritance sucked onto this thing here, so I'm going to give it to them, and Medicaid will pay for it, right?
Right.
What's wrong with that, Brendan?
Oh, yeah, sure. There is one of the biggest eligibility requirements is that there is a 5-year look-back period, and what that means is that if you're transferring assets, you have to think forward 5 years of ineligibility for Medicaid, which is also known as Title 19.
Does that start at the time you receive benefits or at the time you apply for the benefits?
At the time that you apply for benefits. And so ordinarily it's one and the same. So
okay.
The time you're receiving benefits is normally the month in which you're applying for benefits. So at that point, the state goes back 5 years. When I say the state, I mean DSS. That's the agency that processes Medicaid in Connecticut. They go back 5 years to see whether or not you've made any gifts.
So if I'm thinking about doing this and I want to make a gift, but I'm afraid it's going to disqualify me or impair my eligibility or delay my eligibility, what about making a gift of my house for significantly less than fair market value? What's wrong with that?
Well, it's still considered a gift, first of all. A lot of people do ask me that question. What if it's for $1? Is that okay? No, it's still a gift of the entire equity and the property that you've made to your children.
Now, I had somebody who came in and they had this all figured out, and they said, okay, I'm going to sell my house to my daughter, and she's going to pay for it with a promissory note equal to 100% of its fair market value, and it's going to be secured by a mortgage, and we're going to sign a lease, and I'm going to live there pursuant to the lease. Does that kind of chicanery work?
It does not. No.
Does not work.
It does not work. First of all, you haven't accomplished anything because you've sold it for consideration. And number two, if you forgive the debt, the whole idea is you may be able to bypass the capital gains tax issue, and it doesn't work that way.
So this is a lot more complicated than some folks might realize.
Very much so.
What are some of the things that people can do? I mean, you've mentioned gifting, and you've mentioned this 5-year look-back period, so I assume a gift would have to take place before the 5-year look-back period.
Sure.
And since we don't know when you're actually going to apply for Medicaid, we don't know when that 5-year period starts.
Right.
So how do you tackle a problem like this?
Well, it's all dependent on the facts and circumstances, but let's say that we have an elderly couple, a couple in their 70s, and they're relatively healthy. The average nursing home age is 82. I always try to keep that in mind. And so transferring the house may actually be a very viable scenario, but if there are 5 children, transferring the house outright to them can lead to a disaster. And so that's why I ordinarily recommend in those situations using an irrevocable trust as the mechanism to transfer the asset, investing control in one person who's the trustee.
Can the person who's trying to get their affairs in order for Medicaid eligibility serve as the trustee of the irrevocable trust?
No, that is not a good idea. So you want to have somebody, maybe a child, that would be okay, as the trustee, what I refer to as the good child. And everybody's got one in their family.
Yeah, and everybody's got one on the other side of that coin.
Yeah, that's right, exactly.
No question about that. Okay, so that's one of the points that we have to keep in mind, and as we go further into the program, we'll talk a little bit more about revocable trusts, and this will contrast considerably, at least in 2 ways. One, it's irrevocable, and number 2, the person who's the transferor, the settlor, cannot be the trustee.
Correct.
All right. So we've got at least one idea there for doing this stuff. Is this the sort of thing that somebody can read a couple of articles on the internet and then come up with a recipe to make this stuff work?
No, that's very dangerous. And I'm a big proponent of people being able to handle things on their own if they're able to. But in a situation like this, the long-term care eligibility rules under Medicaid are so complicated, and they vary from state to state so much that people can wind up causing financial harm by doing this on their own.
And I'm going to assume that the law in this area is not exactly set in stone, that it changes from time to time, and what may have worked 2 years ago may no longer work, or vice versa?
That's correct, John, and it's fluid. And the regulations are always subject to change, and case law does affect as well what works and what doesn't.
Well, we're going to have to take a break in a minute, so let me just let all of you know that you're listening to Law Talk on WTIC News Talk 1080. I'm Attorney John Metoulis from the Hartford County Bar Association. My guest is Attorney Brendan Daly. He's a principal in the Berlin office of Sapega Daly Pope, a very well-regarded elder law and estate planning law firm. We're going to be taking questions, answering calls. Stephen Weathersfield will get to you on the backside of the break. Our phone numbers are 1-800-966-WTIC, 860-522-WTIC. And if you're using a device where the letters are not as clear as the numbers, it's 1-800-966-9842 or 522-9842. If you're looking for the Red Sox, you got the right station, but the wrong hour. Broadcast time is tonight, and I think it's still the Angels right here at WTIC News Talk 1080. Okay, welcome back, everybody, to Law Talk on an Independence Day weekend. Before we go any further, let's wish each and every one of you a happy and a safe 4th of July weekend. And amidst all the burgers and the celebrations and everything else, let us not forget the reason for the celebration also. Our independence is a really pretty special thing, and let's keep that in mind also. My guest today, Attorney Brendan Daly, a principal in the law firm of Sapega Daly Pope, where he practices estate and disability planning, estate administration. Happy to hear from you at 1-800-966-9842, 860-522-WTIC. It's a great opportunity to get the benefit of Brendan's expertise in this area. Brendan, I realized we're talking a little bit about this Title 19 eligibility business. We haven't really told the audience exactly what the requirements are in order to take advantage of this taxpayer-funded program. So maybe we should get that out there before we get too much farther along.
Sure, be happy to. So Medicaid is the predominant terminology in Connecticut as opposed to Title 19. The eligibility rules ties to assets. For a single person who is in a convalescent home, that person can have no more than $1,600 in total assets to be eligible for this program.
Wow. In
home care environments, though, you can have the same asset threshold for a single person, but there's an income cap of about $2,200 a month.
I have this impression that if you also can like prepay for a burial plot and a funeral, they let you do that at least?
They do, yes.
Okay.
So that's what's referred to as a spend down. Somebody's trying to reduce the size of their estate to qualify sooner for Medicaid by purchasing exempt assets like a prepaid funeral.
So the target, in order to make yourself eligible for this benefit, is to divest yourself of everything except $1,600 total value of your assets, and plus those other two items, and get that all done at least 5 years before you apply.
Well, then you'd be broke for 5 years, so you don't want to do that necessarily, but that's the objective, is trying to reduce the size of your estate. The rules for a married couple are a little bit different and more liberal. The house for the healthy spouse is exempt regardless of the value. The healthy spouse is entitled to keep also 1/2 of the investment subject to a cap, and that cap is $119,000. So the healthy spouse gets to keep that a house, a car also, of any value for both of those assets, and then 1/2 of the investment subject to a cap, a ceiling of no more than $119,000.
I remember hearing a lawyer joking once that with respect to that car of any value business, all of a sudden his clients that drove the Dodge Darts were now driving 500 series Mercedes.
It doesn't work that way.
It does not work that way.
People buy the new Buick. They don't buy a Mercedes.
Right. If you've got a question for Brendan Daly concerning this topic, this is a great opportunity to call him at 1-800-966-9842, 860-522-WTIC. Let's go to Skip in Bristol. Hi, Skip. You're on Law Talk.
Yeah, I got a probate question.
Go right ahead.
This is going to be tough. All right. A sibling. Okay?
Go ahead.
My mother was diagnosed 3 years before this with Alzheimer's. My father was diagnosed with dementia. All of a sudden, one of our siblings shows up with a quick deed, signed by my father and signed by my mother. The entire estate, 3 houses, for $10, because that's what the notary charged to notarize it. For $10, 3 pieces of property are gone.
Who did they go to, Skip?
Huh?
Who did the properties go to?
The sibling.
The one with the deed.
Correct.
Okay. Do you know if they recorded the deed in the town clerk's records in the town where the properties were located?
Well, it's notarized. The problem that we have is we do not believe that the mother, again, our mother who was diagnosed with Alzheimer's and my father diagnosed with dementia, could possibly go to the town hall. Now, the other possibility is that the town clerk went to the house. But we feel that if the town clerk went to the house and or met both my mother and father, she would have realized they could not have signed this.
I understand your point. This type of work is what is called lifetime transfer contests, and I'm going to ask Brendan to weigh in on this in just a minute. But it sounds to me like you got several levels here. You have a question of the competence of the person signing the deed to do so. It's still not clear to me whether the deed was ever recorded on the land records, and if it was not, then that certainly is. Oh, it is recorded.
It is.
Okay.
It is, because every single time, my mother is still alive. So
Okay.
every single time, seriously, every single time I visit my mother, I am told that the property belongs to my sibling.
Well,
It's to the point right now that I was told if I want to visit my mother, now my mother's, I don't understand this because she's living in her house. I don't understand how a landlord, if my sibling considers herself a landlord, can tell me I need to make an appointment to visit my mother.
okay, well, you got a couple
This is
of...
how bad this has got. This is Connecticut probate, and all I found out so far, and I've been at this for a year and a half, Connecticut probate is probably the second worst in the country.
Yeah, well, Skip, we're going to try to help you with your problem, okay? So
Okay,
let me see if we can focus on this. First of all,
Okay.
this involves what's called lifetime transfer litigation. And, Brendan, I don't know if you want to weigh in on that or whether I should just give Skip a couple of thoughts, because this is a lot more than we're going to be able to handle during the scope of this program here. Any thoughts for him, Brendan?
Well, one question, Skip. How is the probate court involved right now?
Right now, I'm going to tell you right now, okay, this is serious, but I don't want to mention which probate court because I was told by my lawyer not to do this. But it's been a year and a half now.
But is
It's
this
kind of unbelievable to me, but this is how it is.
is your mom under a conservatorship?
Yes, she's my sister. One of my sisters is conservator for medical.
Okay.
Under probate, there's a conservator for the estate was appointed by the court.
Okay, so is that a professional person like an attorney or an accountant or someone like that?
Yes.
Okay, so we got the picture now. So it sounds like the person who is the conservator of your mother's person is the one who's calling these shots. I'm going to see if Brendan agrees with me, but my understanding, Skip, is that you and your lawyer can petition the probate court for a hearing regarding the decisions that are being made by the conservator of the person, and you can bring this to the court's attention in the form of a motion, and the court has the authority to have a hearing, listen to both sides, and then make appropriate orders. It would seem to me they would have to somehow demonstrate that your visiting with your mother was not in her best interest in some fashion. Short of that, I don't think that they have any right to prevent you from visiting with her unless for some reason an objective person like a probate judge would conclude it was not in your mom's best interest. Brendan, what do you think?
Let me explain this. This has been going on for 2 years now, a year and a half. Okay. Jesus, I don't know how to explain this. 4 times in the past, say, 8 months, the police department was called. Okay.
By whom?
By my sibling.
Okay.
Okay. The very last time, it was because she calls the police department and she says, I'm carrying a concealed weapon. Well, guess what? I don't own a weapon. I don't have a permit. I've never owned a weapon.
Okay.
So all she does is she calls the police department. She lies. The police show up. I can't visit my mom.
Okay, here's what I think you need to do, Skip. You mentioned that you have an attorney. I think that you and your attorney need to start filing some motions with the probate court and demanding some hearings regarding the conduct of the conservator of the person of the estate. It may be that the sister has some personal vendetta or grudge or for some other reason is not acting in the best interest of your mom. If she's lying to the police, she's also committing criminal acts, and that is something that will get the court's attention. We're going to have to move on, Skip, because we've got some other people
Thank
waiting.
you very much.
But I hope that it helps out. And please let us know in a future show how it works out, okay?
All I can tell you is that your radio station, WTIC, whether it be the news, is investigating. But I can't bring up, according to my lawyer, I do not want to bring up that particular probate court and or the names.
We understand. Skip, thank you for your call and best of luck with that, okay? Take care now.
Yeah.
All right, our phone number is 1-800-966-WTIC, 860-522-WTIC. We're going to change just for a minute here, and Steve in Wethersfield's been with us for a long time. Steve, we're going to go to you on Law Talk, and you're now on the air. Thank you for your patience.
Okay, quick question. Had my property surveyed.
Okay.
All four corners marked. The public sidewalk is on the outside of my property line. Why am I responsible for maintaining the sidewalk? Why am I liable if somebody trips and falls or slips in the winter on my sidewalk if it's outside my property line?
Most towns have an ordinance which imposes the obligation to keep the sidewalk free of clear and ice upon the owner of the adjacent property. I think the theory is that they get the benefit of the sidewalk being there, therefore they should have the responsibility for keeping it free of snow and ice. I didn't ask you you lived in Wethersfield?
Yeah.
Okay, I think you'll find that there's probably an ordinance in the town which requires that, and which if you chose not to do that, they would probably also have the authority to impose fines upon people who didn't do it. So that would be the answer as to where the authority comes from, and it's a pretty common type of thing, Steve. It's not unique to Wethersfield as far as I know. I know of a large number of other towns that impose similar burdens on the owners of private property that is adjacent to public sidewalks.
So I'm also responsible for the sidewalk repairs, and then I'm liable if somebody trips and falls?
No, you don't own the sidewalk. The ordinance generally talks in terms of snow and ice and things of that sort. If you see a defect in the sidewalk, if you see that one of the flags is raised because some tree root is lifting it up, anything of that nature, you call the Public Works Department, the sidewalk inspector, whatever it is that the town has. And they're the ones that are supposed to take care of it. And by putting them on notice, if there's a problem later on, it's going to be more liability for them. We're going to have to break for news, so I'm going to have to move on. But thank you very much for the call. Take care. Okay, we're pausing just for a moment for news. My guest is Attorney Brendan Daly from Sapega Daly Pope. I'm Attorney John Metoulis from the Hartford County Bar Association, and this is our first Law Talk of July, the second half of the year, 2016. We're going to be back with you later on in July also with more programs in legal nature. Right now, time for Aaron Kupek and the news. All right, the boss bumping us back into Law Talk. Part 2 for July 2. A happy Independence Day holiday to everybody. Even if Bruce Springsteen was singing it as a protest song, it's still appropriate for this holiday. We're here until 4 o'clock today, and we're going to get to Ann and Cromwell with her question in just a minute. We've got a line or two open for you also at 1-800-966-WTIC, 860-522-9842. It is my job to let you know that if you need a lawyer and you're not sure where to turn, well, there's a better alternative to the billboards or the internet or, God help us, the back page of the phone directory. The Hartford County Bar Association operates a not-for-profit lawyer referral service. And if you are a regular Law Talk listener, you've heard this, and just bear with me. If you are not, this is a good deal. You telephone them at the number that I'm going to give you in just a moment, so get your pencil out. They'll ask you a couple of questions to help determine the nature of your legal issue, and they will then refer you to an attorney who is insured and experienced in the proper discipline. You get a half-hour consult with that attorney in his or her office over the telephone. That's up to the two of you. And there's no further obligation whatsoever. So what does all this cost you? Well, there's a one-time only fee of $25 to pay for the administrative expenses associated with running this not-for-profit program. Now, if your call involves your personal injury claim, your Social Security disability claim, or your workers' compensation claim, they will even waive that $25 fee. At the end of that consult, if you feel that further legal services are needed or wanted, you're free to speak to that attorney, and if the two of you reach an agreement to go forward, so be it. If you don't, still no further obligation. So how do you access this? You call them at 860-525-6052. That's 860-525-6052. It is a great program. It is sponsored by the Hartford County Bar Association. It is a not-for-profit program, but it is not limited to people people in Hartford County. So if you're within the sound of my voice, you can give them a call. They can help you up or refer you to a similar program in your geographical area. That is the not-for-profit lawyer referral service operated by the Hartford County Bar Association at 860-525-6052. Meanwhile, back here at Law Talk, my guest, Attorney Brendan Daly, a principal in Sapega Daly Pope in the Berlin office. He practices in the areas of elder law, estate, disability planning, and is an excellent resource. Give him a call and make him do some work here. Ann in Cromwell, you're on Law Talk.
Yes, I have a question. I was just out visiting my sister who lives in the Midwest, and we're both older, but she happened to tell me that I needed to get all my assets in a trust because she said, if you go before I do, I don't want to mess around with probate. And
Okay.
I didn't really know what she was talking about. And she said, well, trusts don't go through probate. And I said, well, that may be your law, state's law. I don't know what it is in Connecticut.
And that is an excellent question, and we're going to turn that right over to Brendan Daly. Brendan, you're up.
Okay, sure. Nice to hear from you, Ann. So the question about how living trusts work, and that's what your sister is talking about, a revocable living trust. A living trust is an entity, and what it says is during your lifetime, if you transfer property to it, it's your money. When you pass away, it becomes a will substitute. And so when she's talking about probate avoidance, it all has to do with whether or not you've actually transferred accounts, transferred real estate, transferred other assets to your revocable living trust. If you do that, then she's correct. There's no probate involved when you pass away because the trust then becomes irrevocable. You can't revoke it anymore. And
Because
then
you're dead.
it would be a neat trick. And then the successor trustee would distribute the property to the beneficiaries that you've named in the trust. Whether or not it's good for you depends entirely on your circumstances. I don't adhere to the philosophy that everybody should have a revocable living trust. It's entirely fact-specific. And so if you have, for instance, a dysfunctional family, if you have beneficiaries with special needs, if you have out-of-state real estate involved, where you'd have what's called ancillary probate, these are circumstances where a living trust would be appropriate.
How about tax avoidance, Brendan?
Is not going to help you with any kind of tax avoidance.
And that's one of the biggest issues that people listening should take away from this discussion with Brendan. I think that there's more misconceptions about living trusts and their alleged tax benefits. And you're listening to an expert here. Brendan, no tax benefit whatsoever for the revocable trust, correct?
Correct.
Okay, and I didn't mean to interrupt you, but Ann, you asked an excellent question, and you're giving us a platform here to sort of do a little bit of preaching. So forgive us because it's very important. There's a lot of misinformation out there on this topic.
And I think it would be important for you, Ann, to get some counsel, to see somebody, to see an attorney who practices in this area where you live, and to flesh it out to determine whether or not a living trust is appropriate for you. Just because your sister's saying, yeah, this is a good thing, doesn't mean it's a good fit for you.
One thing that you have to be careful of, Ann, is that there are people out there whose stated purpose is to sell a living trust to anybody and everybody that they can. I'm not going to mention any names, and I'm not going to mention anything about the mode that they do this stuff. But they are not for everybody, as Brendan said, and there are many, many people that probably don't need one who find out after the fact that they've got one, and then to make it worse, they have one, but the assets have not been transferred into it, and it becomes a great big, highly expensive, sort of an empty shopping bag, right, Brendan?
Yeah, agreed.
So just a couple of words that we thought we'd pass along, but it was an excellent question, and you've given us an opportunity to share some information with our audience that very much needs to be shared.
Okay, thank you very much.
Thanks for your call and best of luck. And tell your sister that you've checked. And I think Brendan's advice is good. You need to consult an attorney that does this kind of work and does it without the goal of trying to sell a living trust to everybody and anybody who walks in the door. Okay. Thanks for the call, Ann. Take care.
Thanks.
Okay, our phone numbers, 860-522-WTIC, 1-800-966-WTIC, also known as 9842. If your device, the numbers are easier to use than the letters. Brendan, let's talk a little bit more about this. Supposing I come into your office and, to coin a phrase that you've heard before, my neighbor's got a living trust. Shouldn't I have one too? What's the process by which you decide how you answer my question? Shouldn't I have one also? So take our listeners through that, if you would, please.
Sure, John. What makes us a bit different as transactional estate planning attorneys is that we can't meet with somebody for a half hour or take a phone call for 10 minutes and say, yes, you need a living trust. It is a lengthy initial consultation. It requires some legwork on the prospective client's part. I asked them to complete a questionnaire. What assets do you have? How are those assets titled? Tell me about your family. I need to hear their story. I need to sit down with them, talk about their circumstances, and then at the end of the consultation, an hour or an hour and a half later, I can tell them this is going to be appropriate for you or you don't need it. And a lot of times it's the latter. People come in saying they want a living trust, and I tell them it just doesn't fit the mold. And so you're fine with a will. It's all facts driven.
In the past, we've discussed this with other Law Talk guests, a couple of probate judges that have been on, and one of them basically said, well, what are your objectives? Number one, if you want to save taxes, it's not going to do it for you. Right. Number two, if you want to avoid probate, it's not going to completely do that for you because the assets in the revocable trust are still going to show up in a CT 706 tax return that has to be filed anyway, correct?
Correct, John. Yeah.
But what about privacy? Some people apparently are very, very zealous of the privacy of what they own, and they aren't really happy about having that showing up on a probate court inventory, which is a public record. What about that?
Well, if it keeps somebody up at night having their neighbors look at their obit when they pass away, then go down to the probate court and look at their will, by all means, they should have a living trust because, correct, it is a private agreement. It is not subject to the public viewing at a probate court, and the assets would be distributed to the beneficiaries in complete privacy.
Excellent information on a topic which I think is misunderstood as much as it's understood by the public. We're coming up on a break, so we're going to just remind you, you're listening to Law Talk on WTIC News Talk 1080. I'm Attorney John Metoulis from the Hartford County Bar Association. My guest today, Attorney Brendan Daly, a principal in the law firm of Sabega Daly Pope. We've got a line or two open, and we're only here until 4 o'clock. Bob in Winstead, we're going to get to your call after the break, and we'd like to hear from you also at 860-522-WTIC, 1-800-966-WTIC. More of that after this. All right, welcome back to Law Talk on this Independence Day holiday weekend. I'm Attorney John Metoulis. With me, Attorney Brendan Daly from the law firm of Sabega Daly Pope, and we're answering questions about estate planning, Medicaid eligibility, lots and lots of things of that general nature, and taking your call at 860-522-9842. Next up, Bob in Winstead. Hi, Bob. You're on Law Talk.
Yeah, hi. Good afternoon. About 5 years ago, we co-signed a loan for someone who, after a year, failed to make his payments on the school loan. So we ended up getting stuck. Is there any recourse? What's my recourse on this situation?
Now, when you co-sign the loan, you generally take on the same responsibilities as the maker of the loan, the person who signed it. And if it's a school loan, it's even more difficult because, in general, they're not dischargeable in bankruptcy. Was this a loan that was guaranteed by the government, or was this a private loan?
No, it was through a credit union.
Okay, well, credit unions aren't as bad as some. There are companies out there that make these loans to students at extremely high interest rates, and they're pretty merciless when it comes time to trying to work it out. There's not a lot that you can do, but you can try to contact the creditor and try to work out a plan that's a little more to your liking.
Well, it's paid off.
Oh, I see. Well, then you go after the person who is the student who you helped out with this great big thing and remind them of this big favor that you did for them. So I think that's what you would do with that, Bob. But
we bring him to court, or
no. When you do this, you do it as what's called an accommodation to somebody, and if anything, they have a moral obligation to you, but there's not a legal obligation.
Right. He has to man up and be a gentleman and try to pay me back some way. There's no way to go back and garnish wages or...
No, you don't have a claim against him directly unless you had some kind of another private arrangement with him where you agreed that there would be some kind of reimbursement in return for you doing this if you ever called upon as the guarantor or the co-maker to pay. But it sounds like that's not the case, and that would be pretty unusual in a person-to-person type of context. So I wish you the best with that, but I think at best they have a moral obligation to you, and that's probably it.
That's about it. Okay, thank you.
Good luck with that, Bob. Take care. Okay, a couple of things, Brendan, sorry about that. He's been here a little bit more often than you have.
That's okay.
One of the things that is part of a standard estate planning package, the will, the power of attorney, the healthcare directive, I think is something that we should talk about a little bit further. This third piece of that trio there, the healthcare directive, living will, what is that about, and why is that important for people to think about and to sign in connection with their estate planning?
What I tell people, John, is that disability planning documents like healthcare directives, powers of attorney are equally, if not more important than a will or a living trust because it affects you during your lifetime.
Yeah, it's a pretty good reason to sign them if they're that important.
Yeah, exactly.
To our listeners who may not be familiar with this, exactly what these are, how they work, what the purpose is, and how you select somebody for the role that has to be carried out here.
Okay, so in Connecticut, it's what's called a healthcare representative. That's the terminology where you name somebody to be the surrogate, the person stepping in your shoes and making the healthcare decision that you would make if you're incapable of doing so. And so it presupposes some incapacity in the future where you can't consent to medical treatment. You can't make your own decision. So that person that you name is the healthcare representative, and that person can communicate with your physicians and find out about what your medical needs are. Why it's so important is that if you don't name somebody and you're in that situation where you don't have capacity, then the probate court's going to get involved under a conservatorship potentially. And so this is a private agreement.
I'm familiar with a case where a person had 2 adult children and was in the hospital and needed some particular procedure which his physicians were recommending, and he was unable to consent or to withhold consent. There was no such document. The 2 kids disagreed on this, and one of them even suggested to the physicians, if you go ahead and do this, I'm going to sue you. It's a horrible thing. And in the meantime, the father was there lying in a bed, unable to make the decision himself. So I think stressing the importance of that to our listeners is a very, very good thing for you to do. Now, is there a piece of this also that is what we used to call a living will? And if so, how's that work? What does that basically do? And should people also consider something like that?
Well, a living will is what I tell people, it's a very personal decision whether or not that's something that you should sign, as opposed to a healthcare representative where I tell people you need one. You need to name somebody. So with the living will, this is a document that says if you become permanently unconscious or terminally ill, you would not have life support. You would not have CPR. You would not have artificial means of nutrition and hydration. You would not have artificial respiration. And so when you can't consent to treatment, and if the situation unfolds where that trigger now has been pulled, then you do not have those life support systems decisions. The healthcare representative can also step in your shoes and make end-of-life decisions as well. So it's a dual role for the healthcare representative. They can make general healthcare decisions for you, but they can also make decisions regarding end-of-life treatment.
So I'm inferring from this that when a person signs one of these documents designating someone as their health care representative, that they had better have a pretty good talk with them so that person understands their personal wishes and philosophies in such matters like this.
Correct.
You don't just name them and all of a sudden it's a surprise and, that the doctor says this record in the chart shows that you're the healthcare representative and what do you want to do?
Right.
Just one more little wrinkle that shows why these matters are so important and why it is that someone like Brendan should be consulted if you have issues of this sort that need attention and need to be addressed properly. I want to follow up on something that we talked about just a little bit earlier, Brendan, and that has to do with this topic of trusts that we talked about a little bit. There's a subpart of that which I think I hear more and more about called special needs trusts. Can you tell our audience a little bit more about what those are, who they're for, what the benefit is, or why it is that people would find a benefit in having one of those?
Well, they can be tremendously beneficial to people. It is targeted to assist people who have disabilities and people who cannot work because of a disability, and oftentimes they're receiving public benefits like Medicaid. For somebody who's under the age of 65, this can be a potential mechanism where they can protect their own assets. They can transfer their assets to what's referred to as a special needs trust, and those assets are not counted in determining eligibility for Medicaid, where, as I mentioned before, for a single person, all you can have is $1,600.
So if somebody were to inherit property directly from a parent or a relative, it would impair and potentially destroy their eligibility to either receive or to continue to, or to receive in the future such benefits.
Precisely.
Wow. And that can have a very, very substantial price tag associated with it.
Absolutely. Okay. Because then they lose benefits and may be paying out of pocket a significant amount of money for either nursing home care or home care. And this is a way to protect those assets for them to pay for those expenses that aren't covered by Medicaid.
Sounds to me like an extremely important area, and one where if you need one of these but don't have one, the potential financial fallout from this can be just devastating for somebody.
Absolutely. Yeah. And stepping back at one point, John, the parents in your hypothetical who have left the money to the person with the disability, they should have had a trust. What's called a supplemental needs trust to protect the money for the child.
Got it. All of which shows why this stuff isn't for beginners, and it isn't for people that say, "Well, I read the article on the internet and I got a form from LawZoom," or I'm not going to mention any other names like that. Have you seen in your practice people that have come in with documents that have been generated by some of these third-party internet-based firms? Because I know we see them from time to time, and it's a shame that sometimes even highly intelligent people end up messing them up. I think we've got time for one more call, so we're going to go to that right now. Ann in Meriden, hi, thanks for calling, and you're on the air. Hello, Ann. Listen to the telephone and not to the radio because there's a delay. Going once? Going twice? Ann, can you hear us? Okay, well, we'll just have to wait for a second on that there. Ann had a question about amending a revocable trust, but we didn't have Ann, so let's try her one more time and see if we can get Ann. Okay, Ann, can you hear us?
Now I can.
Okay. You're on the air, and talk to us on the phone. Turn down your radio because there's a 7-second delay between what you say and what you hear.
Thank you. Several years ago, I had done a revocable trust, and then I had an amendment done to it. And unbeknown to me, it had never gotten registered down at City Hall. Now, the attorney no longer practices, and he's not to be found, and I don't know where the records are. Now, we do have the paperwork if something should happen to me. Is the paperwork going to be enough, or does it still have to be filed with City Hall?
Well, and it sounds like the question is really that there was maybe there was a deed that was signed, because a trust is not filed anywhere.
Really?
No, nor is an amendment to a trust. A will is filed with the probate court, but only when you pass away. So this is not a public document that needs to be filed. However, if you signed a deed, that deed would need to be filed with the town clerk.
Yes, I did sign a quit
claim
deed.
Yep.
Yes. So, in order for this to, my wishes be followed, it definitely needs to be updated with City Hall then.
Yeah, It sounds like what you might want to do, Ann, is to just have an attorney review this to make sure there are no other loose ends like that, because one of the worst things is to go to the trouble of having an estate plan done and then find out that it's not being carried out or executed the way you had intended. At that point, it becomes a waste.
Yeah.
But that's what I'd recommend that you do, and I think that'll get you an answer, okay?
They would not accept the paperwork. They said, no, we can't do anything with your paperwork. So.
Yeah, well, they're right, and that music means I'm going to have to let you go, Ann, but thank you very much for a good call. And that music also means that it's time for me to say my thank yous. First of all, to those of you that called in. To my guest, Attorney Brendan Daly of Sapega Daly Pope from their Berlin office for joining us this holiday weekend afternoon. And thanks to Ryan Cosgrove. He's the voice that you hear when you call in. His job is to make us sound good. Law Talk will return, and we'll see you then.
Law Talk is presented as a public service by the Hartford County Bar Association. Its content is intended to be educational and informative, but is not considered to be formal legal opinion. If you want or need formal legal opinion upon which to rely on decision-making, please consider formally engaging an attorney to review all relevant facts in detail and examine the pertinent laws that applies to those facts. A solid opinion means better decisions. The views expressed during this program are those of the speakers and not necessarily those of the Hartford County Bar Association, its officers, or its directors. The opinions and advice expressed on this program are not necessarily those of WTIC. Please consult your own legal advisor for further details.